Ladies and gentlemen, please be seated because the event will start in 5 minutes. Thank you. Okay. Ladies and gentlemen, please be silent. Thank you. Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya, Salam Kebajikan, greetings to all of us. Salam Pancasila. Good afternoon, distinguished ladies and gentlemen. I'm delighted to welcome you to the international webinar entitled Advisory Opinion, New Narrative of the Palestinian-Israel Conflict through International Law Enforcement. I am Muhammad Fazrul Rahadian Cahyanto on behalf of the academic community of Faculty Universitas Pancasila. kindly request all attendees to take a seat. Before we continue, there are a few announcements regarding the rules for this seminar. I kindly ensure that all attendees in this room activate silent mode on their mobile devices. For participants joining via online Zoom meeting, please mute your microphones and turn on your camera throughout the event. Now, let us attentively listen to the welcoming remarks and keynote speech from His Excellency Professor Dr. Edi Pratomo, SH.M.A. You may come forward, sir, and the floor is yours.
Yes, tes. Assalamualaikum warahmatullahi wabarakatuh. A very good afternoon, everyone, distinguished participants, dear colleagues, lecturers, the speakers, and students. Let me first of all convey my special thanks and gratitude to all participants who are gathering at this very special moment in relation or the continuation of our program of the student exchange program, and we are now come to the third stage of our program, namely international seminar. The topic is very much relevant to the topic that has been discussed this morning within the SEP. This afternoon topic is a new narrative of the Palestinian and Israeli conflict through the international law enforcement. So what we are going to discuss is about the legal perspective and especially the issue of the advisory opinion to be initiated, to be decided by the ICJ in The Hague, the Netherlands. We are quite happy this afternoon that we have very prominent resources, speakers from different countries and different universities. We have with us already in the room Dr. Nur Halida. She is representing the Faculty of Law, Malaya University. Thank you, Dr. Nur Halida, for being with us. Thank you once again for being with us today, this afternoon. Dr. Halida is senior lecturer at the Faculty of Law, Faculty Undang-Undang of the University of Malaya. She was also seconded at the Wisma Putra, the Foreign Ministry of Malaysia, as senior officials. We have been duties relating to the international human rights law and international human rights law. She will discuss many issues on the right to self-determination, the basic principles of fundamental freedom of human rights, migration, refugees, and other relevant international conventions with regard to the situation of war in the occupied territories of Palestinian. We have also another privilege to welcome the Professor Chi Yoon from Yongsan University in Korea. Hello, good afternoon, Professor Chi Yoon.
Hello, Professor.
Hi, how are you? Nice meeting you again by Zoom.
Surely, my privilege.
Thank you very much from South Korea. joining us far away from Busan, yeah, one of the province of Korea. Thanks, she is one of the best friend of this faculty of Pancasila University. She has been visiting us many times to this faculty, and nice to meet you again. We would like to discuss a topic which is very serious, very current, and very much challenging topics. I would like to have your views on how do we deal with the questions of advisor opinion at the ICJ in The Hague. Thank you once again, Prof. Ji-hyun. I would also like to welcome Professor Abdel Fattah Al-Awasi. Hello, Professor Al-Awasi. How are you?
Fine, thank you. How are you?
Thank you very much. Professor Al-Fattah is a very senior lecturer and expert, and he has a professional competency in the field of this topic. We intentionally invite him to discuss and to provide us with a legal opinion or legal perspective on how to deal with the questions of two issues. We have two issues now before the ICJ, under the agenda of ICJ. The two issues are now being under consideration. Number one is the application of South Africa against Israel on the basis of the Convention of Genocide, especially with reference to the Article 9 and 2 of the conventions. We would like to have his view, especially on how do we support the decision or the order by ICJ that has been issued 1 week ago. There are many references on the Article 2 of the conventions, especially with regard to the occupation illegally by the Israeli government. And next speaker, we have also the honor and privilege to have Ibu Umi Hani Masud from UITM in Malaysia. How are you, Ms. Umi?
Hi, thank you very much. Thank you very much for inviting me. Thank you.
Thank you very much. I think I have already been in your campus 1 month ago, and I'm afraid that we met already. Hopefully, this is not only the first, but we'll continue the discussion on any topic by inviting yourself to the Universitas Pancasila Faculty of Law. So those are several 4 dignitaries and speakers who are qualified and professional in dealing with the questions under consideration at this very international seminar. We have also at the same time a privilege and great pleasure to have adik saya, my younger brother, Indra Rosandi. He is director Indra Rosandi is now Director for International Treaties, Political and Security Affairs of the Foreign Ministry of the Republic of Indonesia. He has just assumed his new responsibility after arrival from his posting in the permanent mission of Indonesia to the United Nations in Geneva. So he has also having a very professional skill, especially in analyzing the questions under consideration. He is one of the writer and initiator to prepare the statement that is now going to be spoken by foreign minister in The Hague at approximately maybe in the morning Hague time. Yeah. So we have prominent figures, we have prominent speakers, and we are also happy that there are some several representatives from UNDI, from UNPAD, from Warwadewa, from Pancasila University, and especially we have Professor Nurbani coming also a bit long way from KL to Indonesia. Yeah, she has been many times visiting this campus. We are already in one family between and Pancasila. Thank you once again, Professor Nurbani, and thank you Bu Wadek dari Undip for supporting us. And Undip, Diponegoro University and Pancasila University is now already a twin and sibling universities or faculties. Without further ado, I would like to remind us again that we have two questions. Number one, questions of the application of the South Africa against Israel, but the two countries are parties to the Convention of Genocide, so they have every reason to have a case before the ICJ. Indonesia is now supporting the action initiated by South Africa, but at the same time Indonesia now is try to give an oral hearing before the ICJ on the question of the second issues, namely advisory opinion, which is requested by the UN General Assembly last year, December 2023. Without further ado, I would like to invite the speakers and the moderator to come forward, and the Master of Ceremony will invite all of you. Thank you once again for your cooperation, and wassalamualaikum warahmatullahi wabarakatuh.
Test. I extend my gratitude to His Excellency Professor Dr. Edi Pratomo, SHMA, for his welcoming remarks and keynote speech. Finally, we've reached the session we've been waiting for. The presentations by the speakers, followed by a Q&A. Serving as the moderator for today's event is the Honorable Mr. Indra Rosandi, and the speaker that attends offline is Madam Nurhalida. To Mr. Indra and Madam Nurhalida, you may come to the stage, please. To Mr. Indra, you may guide the webinar session, sir.
Tes ya. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon. Professor Edi Pratomo, Dean of the Faculty of Law, Pancasila University, distinguished panels who are joining us online and offline, also distinguished participants. Welcome to the international seminars on advisory opinion. As you can see on the slide, there is on the new narrative of the Palestinian-Israel conflict through international law enforcement. Before we start, once again, I would like to introduce myself. My name is Indra Rosandri. I'm currently serving as a director for the treaties and political and security political and security affairs at the Foreign Ministry. Well, just to start that, before when Professor Edi Pratomo called me just to attend this and moderating this session, I cannot say no, but because Professor Edi Pratomo was and still my mentor, my boss as well when he served at the Foreign Ministry. So definitely can say no in him. But it's honor and privilege for me to be your moderator at this session. And as rightly mentioned by Professor Pratomo in his keynote speech, that I think this discussion on advisory opinion is quite timely, as this marks the first day. This is 19th of February, the opening day of the oral proceedings on the advisory opinion on the questions of the legal consequences on the practice and policies of Israel in the occupied Palestinian territory, which is held now in The Hague, in the ICJ, and it's going to be held until the 26th of February. So just to inform that the first day will be dedicated to the oral statement of the Palestine. And the Foreign Minister Retno Marsudi will deliver her statement on the 23rd of February to represent the government of Indonesia in the ICJ. So that is why this is very important theme to be discussed. And just to set the context for our audience here, that the ICJ has two competence that which are to adjudicate on the contentious case and as well as to render of advisory opinion. And this is one of the core issues that we're going to discuss on the advisory opinion itself. And I don't want to dwell too much. Professor Edi Pratomo has mentioned before that currently there are two cases that are ongoing in the ICJ. The first one, of course, the contentious case on the application by the South Africa, where the ICJ has handed down its provisional measures regarding the application of the Genocide Convention. And the second one is the advisory opinion that was actually has been held and carried out since last year. So this is quite two different cases, but under the preview of the ICJ itself. So today's panel will elaborate and discuss the above proceedings in the light of how international law can contribute and give the perspective from the international law on how we can realize the struggle of the Palestinian people. So we have an standing line of speakers, and certainly we are going to look forward for discussion. I will now introduce again our panel. We have first one, Professor Park Ji-hyun, who join us online. I will just briefly read her CV. Professor Park is a professor at the Yonsam University since 2007, and she is currently serves as a mediator at the Central Environmental Dispute Mediation Committee under the Ministry of Environment. And she also a member of the additional board of the ICRC International Review. The second speakers is Madam Umihani binti Masud. She is a senior lecturer at the Faculty of Law of University of Technology in Mara. And the third speaker is Mrs. Puan Nurhalida, who's joined us here. Welcome, Ibu. Ms. Nurhalida is specialized in international human rights and humanitarian law, public international law, and constitutional law. And she recently completed a 9-month fellowship program in August 2022 as a visiting fellow at City Law School, University of London. And last but not least, we have Professor Abdul Al-Fatah Al-Awasi, who also joined us online. Professor Al-Awasi is renowned leading professor of international relations, and she's currently a fellow of the Royal Historical Society in UK. So now I would like to welcome our speakers and of course indeed convey our deepest gratitude for their participation in this seminar. So without further ado, I would like to invite our first speaker. But before I invite Mr. Professor Park Hyun-jin, let me announce some housekeeping information with regard to the matters of our discussion. So each speaker will be given 50 minutes to prepare and present their views, and then after all speakers have completed their presentation, we will come to the discussion, answer and questions. More or less we have 20 or 30 minutes for the discussion. Without further ado, I will call our first speaker, Professor Park Hyu Jin, to deliver her remarks. The screen is yours, please.
Hello. It is a great honor for me to share the opinion with you guys. Thank you for inviting me to very important discussion on the very urgent matter of Gaza Strip. Let me begin with the issue of provisional measure, because our topic is advisory opinion on those relating to the Palestinian conflict with Israel. 2022 General Assembly asked ICJ to give advisory opinion on that, and that was already given, and the action was not taken from that time. And from seeing the background of other speakers, they will be discussing on the topic of genocide convention, humanitarian factors, and also the general UN matters. So I decided to more focus on the provisional measure. Yeah, because that was a given after October 7, the Hamas actually launched the missile, which is around 5,000 log file orbit, and then next day the Israel started finding those responsible, and then this war began. And then South Africa asked the preliminary and provisional measure on the matter of it, 2023. So as of now, here, sorry, let me just go back. And this is ICJ in The Hague. I have visited last year, and this is a pending case, and this is a procedural matters they have. The topic I focus on now is provisional measure, which never had taken at the stage of PCIJ. Now we are at the ICJ status. So provisional measure at ICJ started the Lagrande case, which is very popular in 1999. And at the time, two issues are at the topic. One is whether provisional measures are enforceable, and second is interpretation of a provisional measure. Because we have this is less important, so let me bring it up first. English version of a provisional measure does not completely 100% reflect the impossibility of a provisional measure. But French version of it strongly and 100% was reflecting the impossibility of a provisional measure. So they were discussing interpretation of the provisional measure at the time, and at the Lagrande case, they decided the binding nature of a provisional measure and the breach of such measure give rise to the international responsibility. So this is the first case. They discussed the international responsibility coming from the provisional measure. And they even mentioned the reparation by not keeping the order of it. So this is the Lagrande case from the bank robber You can just pass. I already shared the information there. And in Israel case here, prima facie in this case, provisional measures require three elements, which is first one is a prima facie jurisdiction, whether the parties in the case have a prima facie jurisdiction to bring the case. Here, uh, the uh, the South Africa asked a dispute of application of a genocide. So the ICJ had to decide whether they have a prima facie case and the jurisdiction. And you can check the signatory of a genocide. And here, I should have checked the South Korea, Israel as a party to it in 1950, and also South Africa is a party to it. Palestine is also the party to the Genocide Convention. Just checking the prima facie jurisdiction, we have to check whether they are a contracting party or not. And second, whether in the first case of prima facie jurisdiction, they should check whether they are the signatory of a contract party of it, and second, whether they have a dispute. In this case, South Africa argued that Israel's action amount to violation, and however, the Israel statement reflects that it all dismiss any accusation of genocide. So the factor, what Israel said is that this is a political statement and political argument. This is not a legal argument. However, ICJ considered it. South Africa and Israel has a different views, and that is dispute. They can consider provisional measure from this dispute. That was it. And comparing to the whether the provisional measure in the provisional measure whether dispute exists, we can also consider Ukraine and Russian Federation case, which is also 2022 case. And in the provisional measure, they asked Ukraine asked. They said the factual dispute and the legal dispute exist. And also the Ukraine asked whether they have a genocide exist. And that was also the very similarity we have in the provisional matter. And ICJ replied, yes, they have a dispute. And here, second requirement and the element is the right preserve and the link between such rights and measure requested. And in this Israel case, South Africa requests to prevent and punish the crime of genocide. And genocide convention, if we apply, they said a national, ethnical, and racial, religious group from act of genocide and any other punishable acts listed in Article 3. So Palestinian here is a national, ethical, racial, and religious group, which is already mentioned by ICJ itself, and they put the evidence of 25,700 killed and other evidence, putting together the facts and circumstances mentioned above are sufficient and plausible for ICJ to provide provisional measure. Comparing again to the Ukraine and Russian Federation case, they also mentioned the Russia Federation's invasion of Ukraine based on the forced claim of genocide is relating to the incompatibility with the Genocide Convention, and it is a violation of Ukraine rights. And because that's the case, and the ICJ also provided a provisional measure to the Ukrainian Russian Federation. Here, the third element is the risk of irreparable prejudice and urgency. So in this Israel case, civilian population in the Gaza Strip remains extremely vulnerable, which is the exact the phrase given by the ICJ. So there is a risk of irreparable prejudice. However, the Israel Prime Minister announced that the war will take more months, many more long months. So, considering these comments, uh, the civilians don't have access to the food, water, electricity, and essential medicine, and also the woman giving birth are likely to experience complication. That's what the WHO said. So there definitely is a risk of irreparable prejudice and urgency required. Although Israel Attorney General stated the call for international harm to civilians may amount to criminal offense. So stop killing civilians in Gaza Strip that was mentioned by the Attorney General. However, ICJ considered this is not enough. So that is why the ICJ provided provisional matter of it. So there is urgency, and the action taken by the Israel was not enough. Also, comparing to the Ukraine-Russian Federation case, here ICJ mentioned all of these, and they also mentioned this is so surprising that the Ukraine and the Russian Federation war will result in additional significant loss of life and property in Ukraine. So ICJ not only considering the current situation, they also consider the further situation coming from the current situation. So ICJ can consider the future aspect of it and provided a provisional measure. So let me just compare. This is an application by South Africa and a provisional measure, and they applied 1 to 9 measures to be taken. Out of 9, 7 are accepted and a little bit of a twisted. If you see it here, number 8, the Israel shall submit a report to the court within 1 week. This is something that the South Africa requested, and the ICJ in the provisional measure, they said they changed it 1 week to 1 month. So a little bit of a change has been made by from the application given by South Africa to the final decision. This is a comparison of a provisional measure given to the Ukraine case and the South African case. Let me compare it. Number 1 to 6. The final decision of a provisional measure given by the South Africa was 6 out of 9. A little change from the ICJ. Number 1 is to take all measures within its power to prevent the commission of all acts written in Article 2 of the Genocide Convention. And second is to ensure the military does not commit any act. But if you compare it to the Ukraine case, they said ensure it, but take no further step in a military operation. So if you compare it to the Israel case here, the military does not commit any action. But in the Ukraine case, it only mentions military operation by all members of meaning here the military or irregular armed units. So this is a little bit concern of me whether because they only mention the military does not commit any act of Article 2 of the Geneva Convention, but because they limited a little bit of a scope of it. But they also mention other actors do not interfere with it. That's a good part of it. Number 3, ICJ gave order to prevent and punish the direct and public incitement to commit genocide. So this is number 3. Number 4, as immediate effective measure to be taken for the basic service and humanitarian assistance. And number 5, ensure the preservation of evidence. So first impression, why do they ask preservation of evidence from the side of South Africa? That's what I thought. And from checking the application, South Africa requested this measure to be taken. So ICJ replied giving cue on the insurance of preservation of evidence. Number six is submit a report in 1 month. And because from, if you see from the provisional measure given to the Ukraine and Russian Federation here, this only said the Russian Federation shall provide a report to the court, a measure taken to implement the court order on provisional measure. So ICJ only requested to provide a report without deadline. So that was the problem because they didn't give the deadline. The Russian Federation did not provide the report immediately. So at this time, South Africa requested 1 week, and the ICJ replying 1 month as a due date for them to give the report. What kind of action has taken to enforce this all those measures? So although I have taken all the materials, let me just briefly mention here. Although the ICJ was not asked to mention this, ICJ mentioned this one, because Hamas abducted hostage and all other armed groups, they should not abduct anybody and call for immediate and unconditional release of it. This is kind of surprising for me that ICJ did something they did not ask. This was not asked by the South Africa, but still mentioned. I like to go to the page. Let me just briefly mention here. This is a convention. Okay. Let me just sum up with it. Here, so far, I have mentioned the provisional measure has enforceability, and this is actually linked to the advisory opinion currently conducting from yesterday. They are interviewing, having a hearing session of all the relevant and interested parties. So if they don't take immediate action of it, 2004 General Assembly request by the done by the General Assembly to the ICJ, decision has been made, but World had done not much about the advisory opinion at that time. So that is a little bit of a regret because we haven't taken on the advisory opinion on the construction of a wall in the Gaza Strip. Hamas, maybe other actors should have taken it because world has not done much of it after the decision of ICJ. This time, if provisional measures are not enforced and Israel keep attacking the civilian in the Gaza Strip, the world might have to do something to immediately stop the attack of it. That might be the sanction enforced to the Israel. That is coming from the enforceability of a provisional measure given at the time of Lagrande case. So I'd like to you to remember the Lagrande case as well, and the 2004 General Assembly and the Security Council asking advisory opinion. and Israel at the time they continuously ignoring it. So they already the ICJ mentioned threat or use of force at any territorial acquisition is illegal, and principle of self-determination people should be respected, which replying the Palestine uh, in the Gaza Strip, not Israel. Israel keep asking and mentioning there are also they have a self determination and they are protecting Israel citizen of it. But the ICC rejected that argument. And also, Geneva Convention has been breached by Israel at the occupied Palestinian territory. There was a decision at the time of 2004, and other speaker will be also mentioning this. So I'll be stopping here. If anything happens further without respecting the provisional measures, maybe the sanction by the General Assembly and uh, maybe that is something the action we have to take because we have an impossibility given by the La Grande case. Thank you. And here is my contact. And if you are have any questions further, you can give me a call or send me a message. Thank you very much. And
Thank you very much. Let's
okay,
give some applause
thank
to
you.
Professor Park, who has presented an outstanding remarks with regard to the provisional measures. And I think I took note that you have made quite a comparative study between the professional measures filed by South Africa with the Ukraine, because it basis with the same basis with regard to application of the Genocide Convention. And also I think you have quite interesting sum up. One of them is I think how this proportional measure can have a possibility to be linked with the advisory opinion. But this is we save it for the discussion. Thank you once again, and now we call upon our second speaker, Mrs. Umi Hani bin Masud, to present her remarks, and the floor is yours. You have 15 minutes. Ibu, please.
Assalamualaikum and good afternoon. Am I audible?
Yes.
All right, thank you very much. Thank you very much for putting this webinar together. Malaysia has been pushing for the rights of the Palestinians at the domestic and international level since we gained our independence in 1957. For instance, now Malaysia prohibits ships flying Israeli's flag or ships on the way to Israel from coming to our port. We also submitted our written submission to the ICJ for the advisory opinion, and we will participate in the oral submission on the 22nd of February. The UN asked for the ICJ's opinion on the occupation of Palestinian territory, annexation, settlements, demographic alterations, and the status of the Holy City of Jerusalem. I will give a short presentation on the importance of the advisory opinion. The advisory opinion is important for several reasons. Firstly, the ICJ deals with the key issue of the conflict, which is the legal consequences of the prolonged occupation. In the 2004 War Opinion, the 2004 War Opinion only specifically focused on the questions concerning the legality of the war and the settlements. In comparison to the 2004 War Opinion, the current advisory opinion or the current request for the advisory opinion addresses the key issues since 1967, which are, firstly, the exercise of the right of self-determination of the Palestinian. Secondly, settlement and annexation. Thirdly, demographic changes. Next, discriminatory measures imposed by Israel and the status of the Holy City of Jerusalem. Perhaps the advisory opinion will expose the reality that the prolonged occupation has morphed into colonization, as Israel has no intention of leaving Palestine. Israel claimed that it no longer occupied Gaza when it withdrew its military operations from Gaza in 2005. However, international organizations, international tribunals, and also an independent commission of inquiry for the Human Rights Council assert that Israel has exercised effective control over Gaza since 1967. Therefore, for 55 years, Israel has ignored United Nations Security Council resolutions. There is impunity towards Israel as no concrete action has been taken against Israel by the international community. The advisory opinion provides the opportunity for the court to examine the right of the self-determination of the Palestinians to be independent and free from colonization. The court can ascertain the legal effect of the policy that has been implemented by Israel and the consequences of those policies to the United Nations and also the international community. Next, the request shows that the ICJ is important for deliberating interstate conflict. As we all know, the advisory opinion of the ICJ is not legally binding on states. This is because the purpose of the advisory opinion is to settle legal questions, and it is not to settle legal dispute between states. Nevertheless, we cannot just ignore the determinations made by the ICJ for several reasons. Firstly, the UN can use the advisory opinion as a guideline in handling the dispute between Israel and Palestine. And secondly, states' views during the written and oral submissions are a testament to global concerns to be addressed by the court. Now, the ICJ becomes an important forum in order to assess the conduct of states. The court ascertains facts in order to determine what happened on the ground, and the court also diagnosed the law. The outcome can be used in order to trigger ways in order to settle the dispute through diplomatic means. Scholars such as Christian Tam argue that we need to shift our thinking that compliance is an essential mechanism of the decision rendered by the ICJ. Instead, we have to think that the role of the ICJ is important in the sense that it triggers the settlement and diplomacy means in order to resolve dispute between states. Lastly, the request significantly impact Palestine, Israel, and the international community. This is obvious in the sense that the advisory opinion shows that international law does not exclude Palestine. It allows Palestine to argue on equal footing with other states. However, outside the judicial process, there is a clear power asymmetry between Palestine and Israel. Nevertheless, with respect to the advisory opinion to be considered by the court, we are not exactly sure what is the outcome of the case. Will the court say that this is apartheid? Will the court say that this is an illegal occupation? What will the court say about the duty of the international community? If you look at opinion by scholars such as Victor Katan, he predicts that the court will at least affirm that there is a de facto annexation and that the international community must not recognize the unlawful occupation. If the court made such a decision, if so, then Israel must end the occupation and uphold democracy. States, especially the Western countries, must take measures consistent with their own democratic value. They must take more leading positions in order to pressure Israel to end the occupation. For instance, states should stop supplying arms to Israel. Corporate entities also must act accordingly and should not be involved in human rights violations. Hence, the United Nations recently released a list of businesses involved in illegal Israeli settlements in order to highlight this issue. That's all from me. Thank you.
Thank you very much, Ibu Umi. Very concise, clear and concise. With regard to your presentation, and there are some important notes that you have mentioned regarding how important the role of ICJ in addressing the issue of the heart of the issue and the conflict, as well as you also endorse how that corporate entity also must not act in supporting the violation of international law by the Israel. Our next speaker, we have Ibu Nur Halida. Apologize. Yes, please, you have the floor, Ibu.
Thank you, Mr. Indra, for your kind introduction. Assalamualaikum warahmatullahi wabarakatuh. A very good evening to all of you here, including students from the various universities, including the students of my Faculty of Law, University of Malaya. Ladies and gentlemen, first of all, I would like to express my gratitude to the Universitas Pancasila, in particular Ambassador Professor Dr. Eddie Pratomo, the Dean of the Faculty of Law, Universitas Pancasila, for the opportunity to speak at your international seminar as a guest speaker. Thank you for organizing such an auspicious event. I appreciate your gracious hospitality and support. On this note, allow me to go straight to the heart of my talk, which begs to differ from the question framed in relation to the request for an advisory opinion of the International Court of Justice, namely the legality and the legal impacts of Israel's ongoing violation of the Palestinians' right to self-determination through the occupation, settlement, and annexation of the Palestinian territory since 1967. I will instead address the Palestinian-Israeli conflict from the perspective of its root cause way back in 1948 and its attendant consequences. Ladies and gentlemen, the nature and essence of conflicts between peoples is in fact conflicts between competing claimants of human rights. This is especially so in the case of the Palestinians, who have, for more than 9 violent decades, persevered in their continuing struggle to survive as a people. During this period, the Palestinians have not only had their lands brutally seized, but they as a people have also been expelled from their lands by the Israelis under the pretense of defending and upholding the rights of the people of Israel to their so-called homeland. The rights of peoples, ladies and gentlemen, to self-determination has been defined as the peoples, in the case of who, shall govern itself, in the case of how, on its territory, in the case of where. An inherent problem with the parameters of the right of self-determination is illustrated in the Palestinian issue in the Middle East, the non-resolution of which is at the very root of very dangerous developments in international law. The problem, a crucial component of the Arab-Israeli conflict, mirrors two competing claimants of the right of self-determination, each seeing the same piece of territory as their homeland. The classic case of oppressed minorities preferring a state of their own other than in the protection of international human rights is, of course, the state of Israel. The state of Israel, born on 14th of May 1948, was carved out of Palestine in the midst of mass displacement and expulsion of the primarily, but not exclusively, Arab population of mandatory Palestine. The overwhelming desire of the surviving Jewish minorities of European states to create a Jewish state capable of defending the Jews everywhere against oppression reveals that they trusted more to the establishment of a state of their own than to the protection of human rights within other people's national states. Therefore, since the inception of the problem in May 1948, when Israel was established on 78% of what used to be Palestine, the issue of the right of the Palestinians of self-determination and the issue of refugee rights of the Palestinians, among other imperative components of the Palestinian human rights related question. The issue of ethnic majorities ruling people who are not citizens and who do not come under full constitutional protection of the national laws of Israel, and the issue of the construction of a wall in the occupied Palestinian territory. They continue to bedevil the international community and particularly the members of the United Nations Security Council despite over 9 decades of the existence of the Universal Declaration of Human Rights. Hence, ladies and gentlemen, the root cause of the plight of the Palestinians is the illegitimate right that granted self-determination to the Jewish minorities of Europe on the premise that in exercising their right of self-determination, the Jews violated not only the territorial integrity of Palestine, but the political independence of the Muslim and Christian Arab majority of Palestine as well. Here, it is pertinent to examine the salient facts that lie at the root of the plight of the Palestinians. And if you may bear with me, I will be revisiting the historical milestones in relation to this particular conflict, starting with the year 1517, when the Ottoman Turks ruled Palestine, where the majority of the population were Arab Muslims. When World War I broke up in 1914, Britain promised the Arabs, including the Palestinians, independence from Ottoman rule in return for their support in their battle against Turkey, an ally of Germany. But the promise of independence did not come. In 1915, to gain Jewish support for its war, Britain issued what is known as the Balfour Declaration, which affirmed the British support for the creation of a Jewish national home in Palestine without violating the civil and religious rights of the existing non-Jewish communities. After the war, the League of Nations divided the defeated Ottoman Empire into mandated into mandated territories, where Palestine then became a mandated British territory. When the League of Nations outlined the mandate for Palestine, it embodied the British government's previously announced policy of facilitating the establishment of Palestine of a Jewish national home, which would involve Jewish emigration from Europe and elsewhere into the territory. The Arabs then felt that Britain had betrayed the Palestinians in handing Palestine over to the Zionists. In the early 1930s, over 100,000 Jewish refugees emigrated to Palestine from Nazi Germany and Poland. Fearing that their mandate would lead eventually to the establishment of a Jewish state in Palestine, the Arab majority argued that the mandate unconstitutionally violated the covenant of the League of Nations by frustrating the national independence for those who were indigenous inhabitants of Palestine, which, as of 1919, Article 22 of the same covenant had provisionally recognized. The Palestinians argued that sovereignty over Palestine, resting no longer in the former Turkish rulers, nor in the League of Nations, nor the mandatory power, must have rightfully belonged as of 1919 to the Arab inhabitants. However, the British view did not place such emphasis on either the legal role of Article 22 nor the League of Nations. Lord Balfour, who had been the British Foreign Secretary at the end of the First World War, concluded that, and I quote, "Mandates are neither made by the League, nor can they, in substance, be altered by the League." Thus, in 1939, although the British government published a white paper restricting Jewish emigration and offering independence for Palestine within 10 years, the Zionists rejected the paper and subsequently organized a series of bloody terror campaigns against Britain and the Palestinians to drive them out of Palestine and to pave way for the establishment of the Zionist state. When the United Nations replaced the League of Nations after World War II, the mandate system was replaced by the trusteeship system. All of the former mandated territories were placed under the system by their mandatories, who were then appointed by their administrating authorities in the same territories, with the exception of certain entities, including those territories, Syria, Lebanon, and Palestine, which had become or were soon to become independent. After World War II, Jewish survivors of the Nazi Holocaust represented the second wave of exodus back to the region. Aggravated Arab resentment of the Jewish occupation then gave birth to the various Palestinian nationalist movements. In 1947, Great Britain, in its decolonization process, decided to withdraw from Palestine. The General Assembly of the United Nations, via General Assembly Resolution 181 of 29 November 1947, decided to partition Palestine into a Jewish and an Arab state, with Jerusalem and its environs cordoned off as a separate entity under the United Nations trusteeship. The legal competence of the General Assembly to establish two independent states in Palestine were questioned on the grounds that the partition plan did not adequately take into account the regard to the principle of self-determination of the Palestinians. On the General Assembly's resolution to partition Palestine, Henry Catan, a Palestinian jurist, noted, and I quote, The Jewish community then existing in Palestine was therefore composed mainly of foreigners, both by origin and nationality. Nowhere except in Palestine have foreign immigrants been allowed to break up the territorial integrity of the country in which they come to live. The partition plan apparently failed. On the one hand, it was favorable to most Jewish organizations, as the plan allowed at last the fulfillment of the dream of a Jewish homeland. On the other hand, it was an unfavorable nightmare to the Palestinians. The Arab states were opposed to the establishment of the Jewish state in a territory where the Arabs were the majority. The partition plan had led to intense disagreement between member states of the United Nations over the fate of Palestine. Fighting between the two communities involving the Zionists and the Palestinians led to the second special session of the General Assembly in April and May of 1948. The General Assembly failed to pass a resolution on the state of its rapidly disintegrating partition plan. Finally, the General Assembly abandoned Palestine to a military solution, with the first Arab-Israeli war breaking out on 14 May 1948 as the mandate ended. On May 14, 1948, with the endorsement of the United Nations, the Zionists proclaimed its independent state of Israel. The next day, the armies of Egypt, Transjordan, now Jordan, Syria, Lebanon, and Iraq joined the Palestinian and the Arab forces to attack Israel. The Arabs lost the war, and Israel gained further territories. Moreover, on 20th May 1948, based on the General Assembly Resolution 186, in bracket S2, Count Bernadotte was appointed as the United Nations mediator on Palestine. It appeared that the very appointment of a mediator was an admission by the United Nations that it had failed to implement the partition. Key problems faced by Count Bernadotte when deciding on proposals for a solution of the Palestinian question included the status of the State of Israel, proclaimed on 4th May 1948, and the status of the Arab state in Palestine, to be created in accordance with the UN General Assembly Resolution 181 of 20th November 1947. In search of a peaceful adjustment of the future situation of Palestine, on 16 September 1948, Count Bernadotte completed his progress report to the third session of the United Nations General Assembly, which was scheduled to begin in Paris on 21st September 1948. The said report entailed, inter alia, a Jewish state territory consisting of only some 20% of the whole of mandatory Palestine, territory significantly reduced when compared with the initial resolution of 29 November 1947. As such, Count Bernadotte was perceived by the so-called Jewish organization, Lehi, as the primary obstacle to an Israeli annexation of Jerusalem and to Jewish control of all Palestine. Consequently, when visiting Jerusalem on 17 September 1948, Count Bernadotte was assassinated by Lehi in the area that had been proclaimed as Israeli-occupied territory. The decision to murder Count Bernadotte was taken by 3 men in the Lehi Central Committee, including Yitzhak Shamir, who eventually became the 7th Prime Minister of Israel. Wars broke out again in 1956 and 1967. By the end of these wars, Israel further occupied the West Bank, the Sinai Peninsula, and the Gaza Strip, then under Egypt, and the Golan Heights under Syria. In sum, ladies and gentlemen, the Arab communities, which constituted most of the inhabitants in Palestine, should have gained independence over their territory in 1947 once the British had left the region. Unfortunately, however, the United Nations General Assembly decided otherwise. Therefore, the United Nations General Assembly should be held accountable for its monumental mistake in the enforcement of a policy which, not being mandatory under any specific provision of the United Nations Charter, nor in compliance with its fundamental principles and purposes, is clearly incompatible with the valid nationalist aspirations of the Palestinians under international law. Thus, the claim of Jewish minorities of European states to self-determination, albeit the creation of Israel, puts a test to the parameters of the right to self-determination under international law. Once international law recognizes self-determination as a right, its parameters ought to be set and regulated in order to avoid a situation which might endanger world peace, order, and stability. The issue of parameters of right of self-determination necessitates a review of the main theoretical definitions of self-determination and its legal status under international law, followed by the development of the concept throughout the 20th century. The analysis of this important topic offers a starting point for discussing the legal arguments related to Israel's right to exist and the validity of Israel as a legitimate sovereign state. The question to be posed here: was there a legal right of Jewish minorities of Europe under international law in 1948 to self-determination? Ladies and gentlemen, the answer to this legal question depends on the legality of the Balfour Declaration of 1915, which provided a foundation for the British mandate in Palestine, given that the Balfour Declaration was a mechanism which eventually led to the partition resolution of the UN General Assembly in 1947. My argument is that if the linkage was illegal, the consequences would be challengeable under international law. Was the Balfour Declaration, in granting a national home in Palestine to Jewish minorities of Europe while ignoring the will of the Muslim and Christian Arab majority and preserving only their civil and religious rights, repugnant to international law? The issue regarding the legal validity of the Balfour Declaration and its impact on the British mandate in Palestine necessitates a perusal of the parameters of self-determination and its legal status under international law, as well as the development of self-determination from principle and eventually to right under international law. On the one hand, it has been argued in favor of the right of self-determination of Jewish minorities of Europe that the legality of an action is determined in the light of the law in force and it was affected, and not the law prevailing when its validity is challenged. Hence, the British mandate in Palestine, as well as the partition resolution of the UN General Assembly, were claimed to be not contrary to any existing legal principle of right of self-determination under international law. However, on the other, it is submitted that premised on the doctrine of intertemporal law, as elaborated by Judge Huber in the Island of Palma's case, a distinction has to be drawn between the creation of a right and the maintenance of that right. Consequently, a right may be validly created under the rules of international law existing at the critical date, but whether the right can be maintained has to be assessed according to the rules of international law as they exist. Thus, in exploring the concepts of self-determination and minority rights in international law and their development over time, beginning with the period during and following the First World War, it may be argued, inter alia, that it is questionable whether the United Nations Charter ever contemplated the question of minorities in its self-determination provision. The problem of minorities was...
Excuse me, Ibu, you have 30 seconds more.
Okay, and is still perceived more as an issue of universal human rights than one of self-determination. If I may, Mr. Indra, can I make a few points before I conclude? Okay. So, in relation to the Balfour Declaration, the right of self-determination as developed in international law is generally held to belong to peoples and not to minorities. No legal basis for the Balfour Declaration to prefer the territorial aspirations of Jewish minorities of Europe over the Muslim and Christian Arab majority. Therefore, I would argue it was an illegitimate right that granted self-determination to the Jewish community in Palestine to the detriment of the legitimate rights of the Palestinians in all of Palestine. Since I have time constraints, I was planning to talk about the consequences of the illegitimate exercise of right of self-determination on the part of the Jewish minorities of Europe. However, just to simplify, I would like to underline that because of the root cause of the Palestinian-Israel conflict in the sense of the exercise of the right of self-determination wrongfully exercised by the Jewish minorities of Europe, consequences ensued in the form of issues relating to terrorism, whereby the issue relates to the definition of terrorism and whether or not it should include people who are fighting for self-determination. Another issue that is related and form as part of the consequences of this plight of the Palestinian would also refer to the right of self-defense, whether or not such a right is available at all to Israel in dealing with the Palestinians. So with that, let me conclude in 1 minute. In 1 minute. I would conclude, first of all, the UN General Assembly is held accountable, or should be held accountable, for its unratified mistakes, committing blatant violation of rules of international law in 1948, thus preventing the Palestinians to fully exercise their legitimate rights of self-determination in their own homeland. Secondly, unless and until remedial actions are immediately undertaken, all the attendant consequences, as I mentioned before, as the result of the illegal creation of Israel, will continue to abhorrently cause untold human misery. Thirdly, the United Nations General Assembly should take unprecedented steps to immediately enforce remedial measures for its actions in 1947, namely undoing the disproportionate and inequitable partitioning of a territory earmarked for independence, which should have resulted into an Arab as well as a Jewish state, with Jerusalem and its environs cordoned off as a separate entity under the UN trusteeship. It's imperative for international law to permanently bring to a close the continuing and untenable situation affecting Palestinians in Palestine, which reflects despicably the aberrant disgrace to mankind, the illegitimate creation of Israel under the auspices of the United Nations. Lastly and finally, unless and until the remedial actions are immediately undertaken, all the attendant consequences as the result of the illegitimate creation of Israel would continue to cause untold human misery. Thank you for your attention.
Thank you very much, Ibu Nur Halida, for a very interesting information, and I think you observe quite interestingly on about the denial of the legitimate right to self-determination of Palestinian people from the historical perspective and also international law, and you also provoke the UN to rectify its mistake and take remedial steps. This is very interesting, but I will leave it to the discussion part. And last but not least, we move to our next speaker, Professor El Awasi. I will now invite Professor El Awasi to present his remarks and thoughts. The
Thank you.
screen is yours. Please, Professor.
Thank you very much. Assalamu alaikum and good morning from cold Britain here in Edinburgh, the capital of Scotland. Thank you very much for inviting me to share my opinion as a scholar of international relation. But before I share my professional opinion, I would like to point out that I am the son of Nakba survivors. My father was Nakba survivor. My mother was Nakba survivor. My grandparents were Nakba survivors, and also some of my sisters also were Nakba survivors. So I felt to point out this before I start my professional opinion as a scholar of international relation. One party to this conflict is Israel. And what I would like to share with you, what is the nature of Israel? We talked about, the previous speakers talked about Palestinians, Arabs and Christian and Jews also. But what is the nature of this party? Sometimes we ignore to understand. So I hope what I will be sharing with you will give a better understanding of this party to the conflict, Israel. And in light of the British documents revealed by the British government, which I spent several years studying in the first half of 1980s and other available sources, lasting 40 years of studying these documents between 1983 and 2023, I found that Israel is not a state. This might be a shock to some of you. To prove this, I will be examining historical and recent document related that Israel is not a state. And I will share with you, if it is not a state, what it is. The project was initiated by Christian religious leaders in Britain since 1800, then fostered by the British state by the opening of the British consulate in the Holy City of Jerusalem in 1938. Then it was strategically adopted by the builders of the British Empire in 1840. In 1840, before the emergence of the Zionist movement in 1897. This is very important to note. And currently, this is sponsored by the United States of America. What was the aim of this project? According to this document, The aim was to establish, quote, a foreign human barrier, end of quote, in the southwestern part of the Levant. It took Britain over 108 years to achieve this aim, from 1840 to 1948. So let me start with first historical document. Part of Britain's famous policy, divide and rule, the initial step was the isolation of Egypt from the Levant. That dated back to the 15th of July, 1840, when the major power, including Britain, signed a treaty to isolate Egypt. The correspondence between the British Foreign Secretary, Lord Palmerston, and his ambassador in Istanbul, in particular Palmerston's memoirs dated the 11th of August, 1840, and his letter in February 1841, revealed the true objective of establishing a barrier or a human, of a bridge or a human barrier, which was to create a regional area within the Ottoman Empire under the British protection, forming an obstacle or a barrier preventing the establishment, and I would like you to look at this, preventing the establishment of political unity among the Arab provinces. The Ottoman at that time was collapsing. That's another issue. This led to the British occupation of Egypt in 1882. This is one document. The second historical document, called Campbell-Bannerman Report of 1907. I'm talking before Balfour Declaration, which my colleagues highlight excellently. Campbell-Bannerman Report of 1907, prepared by a committee specialized in colonial affairs from 7 European countries, including a group of leading scholars in history, sociology, economics, agriculture, geography, and petroleum. It emphasized that the real source of danger to Western colonial state lies in the Arab provinces and in the Arab people living there. To deal with this potential threat, potential danger, as they said it, the report recommended the following measurement, and I would like you to pay attention to this measurement if you don't mind. The first recommendation, working to create a state of disintegration, fragmentation, and division in the Arab region. Secondly, establishing artificial states subordinate to Western colonial power and under their control. Maybe you can imagine what is happening now in 2024. Number three, combating any form of intellectual, spiritual, or historical unity, and implying all available strong means to separate the region and its people from one another. The fourth recommendation, which is called urgent recommendation, to implement the above three recommendations, it is necessary to work on, I quote, establishing a strong and foreign human barrier on the land bridge that connects Europe to the ancient world and links them together with the Mediterranean Sea, creating near the Suez Canal a force hostile to the people of the region and friendly to the European states and their interests, is the urgent practical implementation of the proposed means and methods. Indeed, this report served as a green light for the British practical policy. Then in 1917, the British occupied Palestine and the holy city of Al-Quds, and we have the Balfour Declaration in 1917. From 1917 to 1947, Britain facilitated the establishment of their project Israel. So what was the objectives of this Western colonial project? From studying these British document, it revealed to me 5 main objectives. The first one, protect the human barrier, Israel, and secure its existence. And this is the language we hear from the government of Britain now, most European country, and the United States. Protect the human barrier, Israel, and secure its existence. That's number 1. Number 2, maintain the state of fragmentation and disunity in the Arab region and prevent any real unity among its country, which is we can see now. Number 3, economically control the resources of the Arab region, which we are witnessing for a number of years. Number 4, prevent the emergence of any Muslim power in the Arab region and West Asia. The last one, prevent the rise of any Sunni Muslim revolution in the region. The question which I would like to ask, are these goals still relevant today? The answer, yes. The following evidence I will share with you confirm that it is ongoing. I will share with you a number of documents. These are recent documents. 60 years after the establishment of Israel, Gordon Brown, while he was the British Prime Minister, stated on the 8th of May 2008, I quote, the establishment of the State of Israel was one of the greatest achievements of the 20th century, end of quote. In 2017, 100 years after the British occupation of Palestine and Balfour Declaration, the British government still insists on its stand. Theresa May, the British Prime Minister at the time, refused to apologize to the Palestinians. I quote, Her Majesty's government does not intend to apologize. We are proud, I would like to pay attention to this part of the quote. We are proud of our role in the creation of the State of Israel. End of quote. My other document, Mr. Aznar, the Prime Minister of Spain from 1996 to 2004, wrote an article in the Times of London on the 17th of June 2010. Title, what was the title of his article? Support Israel. If it goes down, we all go down. End of the title. He described Israel as, I quote, our first line of defense in a troubled region, a region vital to our energy security, and the front line in the war against extremism. If it fall, we will all fall with it. I will repeat this. If it fall, we will all fall with it. Israel is a fundamental part of the West. End of quote. The current US President, Joe Biden, his history is marked by absolute support of Israel. In 1986, he stated, I quote, if Israel did not exist, the United States would have to invent Israel. To, pay attention to this part, to protect American interest. I will say this again, if you don't mind. This was in 1986. If Israel did not exist, the United States would have to invent Israel to protect American interests. In 2007, he said, I quote, Israel is the greatest strength America has in the Middle East. I will repeat again. Israel is the greatest strength America has in the Middle East. Imagine our circumstances in the world without Israel. End of quote. In conclusion, I would like to stick to the 15 minutes. In conclusion, what we have been witnessing in the last 136 days since October the 7th of 2003 in Gaza Strip are massacres, ethnic cleansing, genocide, and other war crimes led by American administration, United Kingdom, and other Western states. These are proof evidence that the American administration, the UK government, and other governments are fully responsible for paving the way for all war crimes in Gaza Strip. The blood of Gaza is on their hands as much as on Israel. I wrote 2 letters, formal letters, to the British Prime Minister. One in 31st of December 2003, and the other one on the 24th of January 2004. I would like to share with you one quote of what I have written to Rishi Sunak, the current British Prime Minister, in my letter on 31st of December 2003. I quote, the UK government complicit in Israel war crime in Gaza Strip, with the blood of Gaza equally on the hands of the UK government as it is on Israel. Finally, I hope I presented from these documents, historical documents and current document, that Israel is not a state, but a Western colonial project in the Arab region. Thank you very much indeed for listening to me.
Thank you very much, Professor Al-Awasi, for your perspective. You have broadened our knowledge as well with regard to the wide range of violation of international law committed by Israel and its allies, from, of course, a historical perspective as well, and thought-provoking conclusion that you have provided with us. Now we have exhausted all the speakers. We have 15 minutes, more or less, for question and answers. I would like now to invite all the participants who wish to ask questions or make comments to the panelists. Please raise your hands. The first 3, I will now invite first 3 participants. Please indicate your name, institution, and to whom you address your question. First, yes, number 1, and the second is at the back, and the third one is, yes, please, the first question. Yeah.
Hello everyone, my name is Shashmita and I'm a delegate from University Malaya. My question is generally to all the speakers, because from my understanding and reading, I understand that ASEAN countries, which are all present here, often advocates for a 2-state solution to Israel-Palestine conflict. However, firstly, why didn't the ASEAN countries themselves bring a case against Israel to the ICJ? Why was it South Africa? And secondly, despite this two-state solution urged by both states, in your legal opinion, does the current actions of ASEAN states taking a firm stance against Israel as of late conflict with the initial 2-state solution? Yeah. So it's a two-pronged question. Thank you.
Okay, thank you. Now, I think we collect the question first, and then I will invite all the speakers to respond. Yeah, this second question, please.
Yes. Okay, thank you. Good afternoon, everyone. My name is Rino Naziatatur from a delegate from Pajajaran University. So, currency of international law is being tested for legality to the international community. This is especially true in the current conflict between Israel and Palestinian. Some of the consequences caused in war are violence against one's body, hostage-taking, harassment, and rape. Saying this is certainly an international concern, the United Nations, as an organization that helps maintain and preserve international peace, certainly does not remain silent about the situation. Especially in conflict between Israel and Palestine, some of the conventions that regulate armed conflict are the 1907 Hague Convention, 1949 Geneva Convention, and Additional Protocol 1 to 4, 1977. But it can be seen on social media, especially Instagram and Twitter, a journalist from Gaza, Motas Azaiza, where Israeli soldiers easily kill civilians and destroy all health facilities, even without food donation from other countries for Palestinian. So the question is, but why are there still many countries that support Israel genocide against Palestinian, and there are no sanctions given by the world for Israel? And the last question is, are the Hague Convention and Geneva Convention 4 applicable to Palestinian conflict territories according to the International Court of Justice? Thank you.
Thank you. Yes, thank you very much. Before I give the floor to the next one, namanya siapa tadi? Andrino. Rino. Dari Unpad ya. Your question is addressed to all the panelists. Yeah. I hope you can grab some of the question because there are two questions. Okay, now the third one, please.
Thank you for the opportunity. My name is Keilana Jani Saputra. I'm also the delegate from Universitas Pajajaran. My question is
Dipanggilnya
also...
siapa, Mbak? Dipanggilnya siapa?
Keila.
Keila.
My question is also for all the panelists here. So recently, on December 12, 2023, the United Nations General Assembly passed a resolution that called Israel for a ceasefire in Palestine amid an intensifying humanitarian crisis in the Gaza Strip. The General Assembly resolution came after the United Nations Security Council, the only body in the United Nations with the power to pass legally binding resolutions, was unable to pass a ceasefire resolution because the United Nations vetoed it. So my question is, what is your opinion as a scholar regarding how far should the veto rights, especially from 5 permanent members of UNSC, be held? Seeing that the ceasefire in Palestine could have already been implemented if the veto rights of the permanent members of UNSC had been reconsidered. And that is all from me. Thank you so much.
Terima kasih, thank you, Mbak Keila. Okay, now I give the floor to all the panelists to respond to the questions put forward. I'll give the floor first to Professor Park. Yes, please. Yes.
I got it. Yeah. Somehow. About the question, why the questions are all good. Students have listened and participants are really acting quite nicely to understand and solve the problem. And the question about the why it is a South Africa, I also had the same question with the others and discussed it. And I see they also discussed it. Why is it South Africa? And they mentioned that any state and any contracting party in a Geneva Convention and also the UN ICJ agreement, they have a standing and they can issue. Asian country may participate in standing and can request the provisional measure and also the request and bring a suit too. But this time, South Africa took a position of requesting the measure first. It is not the position of Asian country objecting the South Africa. They agree to the position of many other countries for stopping the violence in the Gaza Strip. It is just that they all and any country in the UN and participation in a Geneva Convention have standing. So it should be the party to the Geneva Convention. So South Africa took the step. Also, the sanction, as Professor Umi mentioned it, sanctions are taken by individual countries. So it depending on the countries, many countries already took individual the national sanctions. Although from the perspective of South Korea, we took a lot of sanctions against North Korea, but it seems the sanctions has not been working very well against the developing a nuclear power in North Korea. But however, sanctions reflect a lot of meaning in international society. So it will be furthered by it if the U.S. and some of the other countries take a further step and active step on it. And third question on the Geneva Convention, of course, it is a breach of the Geneva Convention 1949 and 1977. But because prima facie case has to be satisfied, that's why South Africa took a step on the Genocide Convention instead of a Geneva Convention, because they have to prove prima facie case. Of course, Ukraine case, they took a stand on the Geneva Convention too. So of course, South Africa can issue and ask for the Geneva Convention breach too. But this time they had taken a step in the Genocide Convention because it brings a more issue on the international community, I think.
Thank you, Professor Park, for your response. Now, Ibu Umi, give you the floor if you have any response from the questions. Thank you.
Thank you very much for the questions. So the questions are good questions. They are great questions. I think I will address some of the questions. I did not get some of the other questions, but two questions. I think I managed to get two questions. Firstly, concerning why ASEAN countries. I think this is concerning the action taken by Africa. In which Africa exercised its rights as one of the state party to the Genocide Convention to initiate action against Israel for the violation of the Genocide Convention. I'm not exactly sure the position of other ASEAN countries, but one thing that I can say about Malaysia, Malaysia made a reservation to the Genocide Convention. We made the reservation to the settlement of dispute clause, the compromissory clause in the Genocide Convention, in which, according to the recent case decided by the court again in the Ukraine and Russia Federation case, it is again there was an attempt made by the US to intervene in the proceeding. However, the court decided not to allow the intervention made by the US because of the reservation made by the US, the Genocide Convention. Malaysia made the same reservation to the compromissory clause of the Genocide Convention. And I think that is the main reason why, at least for Malaysia cannot, or Malaysia, because of the reservation, Malaysia cannot be involved in the initiating of the action on the basis of the Genocide Convention. And then I think another question is concerning what is the law applicable for a state who has been occupied by another state. If I'm not mistaken, that is the question. So when we talk about the law governing occupation, so firstly, obviously the international humanitarian law is applicable during the situation of occupation. Human rights law is applicable during the situation of occupation. And at the same time, the law concerning the use of force, the law concerning self-determination, and also the law of state responsibility. These are the laws that govern the conduct of the occupant when they occupy the territory of another state. And I think another question is concerning sanction. Again, in this situation, speaking from the legal perspective, I'm not a politician. So on that basis, when we talk about the implementation of international law, it is as good as the willingness on the part of states to implement it. We cannot deny the fact that when we talk about international law, it connotes the real the geopolitical issue is part of the reality of international law. So on that basis, it takes political will on the part of states to implement international law. Right? I think I hope I get the questions, most of the questions. Thank you.
Thank you. Professor El Awasi, and then if you have any thoughts on or respond.
Yes, I think I will just respond to the issue of the two-state solutions, because every time I'm in part of Southeast Asia, this question came to me very clearly about the two-state solution. If you study any course in conflict resolution, you will understand. By the way, conflict resolution is part of international relation. So if you study any course in conflict resolution, you will understand there is a big difference between solving conflict and managing conflict. There is totally different between solving conflict and managing conflict. The two-state solution was a Zionist propaganda to manage the conflict, not to resolve the conflict. Basically, Israel and the Zionist movement tried to buy times since 1967 to gain more lands, establish more settlement, confiscated land, deported Palestinian, and so on. And maybe it was very clearly with the Oslo Accord, where they gave them an upper hand and they manage this conflict for them. Now, Netanyahu is saying no two-state solution, because the propaganda for the two-state solution served its purpose. And now he is saying we can't have a Palestinian state. So, in a very short answer, the two-state solution was an Israeli propaganda to gain more time, which unfortunately the international community gave them that platform, and now they are saying no two-state solution. And I think the two-state solution, since the fall of Oslo Agreement, the Palestinians tried to establish peace with Israel for 30 years. And this is showing to the international community this Western project is not willing. It is an occupation power. And people need to recognize this is an occupying power part of a Western project. This is very important to mention. This is what I can respond to these good questions. Thank you.
Thank you, Professor. Ibu Nurhaida.
Thank you for the questions. I just want to add to the answers that were already given by the previous speakers. Based upon the questions raised, there were questions relating to the role of international humanitarian law, as well as the role of the United Nations Charter in addressing the Palestinian-Israeli conflict. Now, here I would like to draw the attention to the very nature of international humanitarian law as compared to the United Nations Charter. In particular, Article 2, Clause 4 of the UN Charter, as well as Chapter 7 of the UN Charter. Now, in terms of IHL, there is a particular section of the Fourth Geneva Convention that deals with the rights of the inhabitants of the occupied territory. And on that basis, we find that international humanitarian law, the essence of IHL deals with the conduct of hostilities and the treatment of persons in the hands of the enemy. That's the very essence of international humanitarian law, first of all. Secondly, when it comes to the notion of enforcement of international humanitarian law, it's very much lacking. There is a lack of mechanisms in order to enforce the provisions of the Geneva Conventions, the 4 Geneva Conventions, and the additional protocols of 1977. And that was the very reason why the international community took the step to establish the Rome Statute in order to create the International Criminal Court. Another point I wish to make is that when we talk about the role of the UN Charter, unlike international humanitarian law, which deals with the conduct of hostilities and treatment of persons in the hands of the enemy, the UN Charter, in particular Article 2, Clause 4, read together with Article 51 of the UN Charter, read together with Chapter 7 of the UN Charter, such provisions deal with what is known in international law as jus ad bellum, meaning, in other words, the entitlement to engage in hostilities. And that is very much dependent upon the role of the Security Council. And when you talk about the role of the Security Council, we need to bear in mind that the Security Council has the primary responsibility to enforce international peace and security. Okay? However, the problem is whether or not such enforcement is actually carried out by the Security Council would depend at the end of the day upon the powers of the 5 permanent members, whether or not they are willing to take action, because this is subjected to the veto powers which are given to the 5 permanent members of the Security Council. I hope that would be sufficient to answer the question.
Thank you very much to all the panelists. I would like to remind all of us that we only have like 5 to 10 minutes left. We are behind schedule. I would just give for the 2 last questions, if you have. Only one? Only two. So please be concise and to whom you are addressing the question first. And on the left wing, yes. Speaker. Okay. The first one, please. Your name, where you're from, and questions too.
Okay, thank you for the opportunity. My name is Sultan, and I'm also from University of Pajajaran. My question is pretty simple. We have had a long history of conflict. You know, throughout history, mankind has a long history of conflict. And instead of creating a law that bans war itself, we created a law that sort of facilitates war, a law to manage conflict in the humanitarian law, the rule of law, the rule of war. But if the Israeli-Palestinian conflict has showed us anything, it showed us just how unpopular the humanitarian law has become. And through this display of unpopularity of humanitarian law, I think this question is directed to all the speakers. What should we do, you know, seeing the unpopularity of the rule of war? Should we revise a new system of law? Should we revise a new way to enforce the law? Or should we revise the existing humanitarian law? I think that's all from me. Thank you.
Thank you. Second questions? Yeah.
Hello, assalamu alaikum everyone. My name is Hazrat and I have a question for the second speaker, Dr. Umi. So, Dr. Umi, just now I quote, you said that the ICJ can use these advisory opinions that are submitted to handle the dispute of the Palestinian-Israeli conflict, and that these advisory opinions are not binding. So, let's say if it's not binding and ICJ does use and refer and follow it, what can ICJ do besides ordering economic sanctions? Like, can you punish the country itself, or maybe you can try the Israeli leaders for war crimes? And what if Israel still continue to annex and occupy Palestine after being tried in ICJ? So that's my question.
Thank you. And where are you from, Azara?
I'm from UiTM, Malaysia.
Okay. Yes, thank you. Now I give the floor to Professor Park.
Okay, there are two questions uploaded in the chat box, but I just checked the first one, and the question from the first student there is very similar to the question on the chat box number one. So what can we do because of the IHL become not popular and does not give a solution to it, is that IHL is humanitarian law is having the purpose of protecting civilian and setting the rule of war. However, we are much focused on the protecting the civilian now. If that is a question, then the humanitarian corridor may be the option for them, so they can move out, evacuate with protection under the UN and also the group of people from ICRC. Humanitarian corridor can be if we apply this will be the third time the humanitarian corridor will be applied to the war situation. For the if they don't move out, the option is that we have to stop both of the parties to bombarding the civilian population, right? For that matter, we have to negotiate each party with a neutral position. Somebody has to have a mediation stage, settling their I think opinion and the argument of it. So it will be a little harder. ICJ decision, of course, the Professor Umi will answer it. Advisory opinion is not enforceable, though. They have an international society watching, so we can all agree and moving to the economic sanction. Not only that, but we can also have bring them to the further the Rome Convention also forced them to go ICC, so we can push them to go further on that. We all want any of the civilian to be hurt and in any of the situation here. That's all we hope. Thank you.
Thank you. I will leave the last response to Professor Umi, but now Professor El Awasi, if you have any response for the questions.
Well, you notice from I'm a scholar of international relation more than of international law, but as a human being, I feel ashamed that we are witnessing this genocide. Previous genocide, we don't have social media, we don't have things reported. Now, we, in a daily basis for 136 days, we are witnessing this genocide, and the entire world are silent. Even governments, they Western government, they are complicit. I don't have any single doubt on that. And I applaud South Africa, which experienced what the Palestinians are experiencing now. Even they said South Africa, what the Palestinians are experiencing is worse than apartheid South Africa. So they took the case because I feel they are free nation and they stand up for the suffering of the Palestinian, and this is why they submitted the case to the International Court of Justice. I hope other country will follow. If they can't be the lead, at least to follow and to support the case of South Africa. Because, as I said, as a human being, I feel ashamed. I feel ashamed that this is happening in front of our eyes and we are doing nothing, nearly nothing. In United Kingdom, for example, in London and in Glasgow, just yesterday, were a huge demonstration, we haven't seen in any other country, in the Muslim country. We haven't seen. At the beginning, Muslim country were rising, and now they are dying. They are living, unfortunately, with the genocide. It's a shame in everyone who can do something and they don't do anything. So I applaud again South Africa and any country supporting South Africa in the case. This is a test to our humanity. This is a test to our humanity. And it seems, after 136, we failed. Can I share with you that until now, no single box of medicine reached Gaza. No single box of medicine, where all hospitals, it's not working nowadays. People are dying from hunger. This is where I feel ashamed. Where people, they have plenty of food, plenty of drink, and people are dying in front of our naked eyes. They are dying. Yesterday in North Gaza, 4 individuals died as a result of hunger, famine. This is why I feel ashamed as a human being. And we should do everything we can. For me as a scholar, I wrote to my Prime Minister in the UK. I wrote to him very harshly. I'm challenging him. I did not share everything I said in my letter. I lost 25 members of my family, they have been killed by the Israelis in one strike in Christmas Day on the 25th of December. So I feel all of us should feel ashamed, and we should do the maximum, the utmost best to prevent this genocide. If this is not genocide, what it's? I need someone to define it to me. If this is not genocide, I don't know what to call this. Maybe there is another word for genocide, worse than genocide, which is happening in front of our eyes. Yeah, in Britain we have the general election this year, and a politician knocked my door 2 days ago, asking me to vote for Labour. I said, I'm not voting for Labour. I used to be a supporter of Labour. I'm not voting for Labour because you are complicit. Your leader, your boss, even did not call for a ceasefire when there was a debate in the British Parliament. So we can do, if we are willing to do, and to stop the suffering of these innocent, hopeless Palestinians in Gaza. Thank you.
Thank you, Professor. I've been told that we are reaching the end of time, unfortunately, but I will just give 2 short comments from Ibu Nurhalida and Ibu Umi, because I think one question is directly to you, addressed to you, Ibu Umi. Ibu Nurhalida, please,
Yes,
before we close the session.
Thank you, Chandra. Just a short comment, just for us to remember that the Palestinian-Israeli conflict is the longest conflict that has not been solved since the United Nations was created in 1945, and it's high time for the international community to do so, because as long as this conflict is not solved, there will be little chance for other conflicts that are ongoing in this world to be solved accordingly. Thank you.
Thank you, Professor. Ibu Umi, please.
Very briefly, firstly, concerning the lack of enforcement on the law of armed conflict, I see this is where, for me personally, ICRC should play more active role in condemning actions of the parties to armed conflict if they have violated the law of armed conflict. But we do know that ICRC has to act in accordance with the principle of neutrality. So in my personal opinion, there is a need for another body that is capable of condemning states if they have violated the law of armed conflict. If the ICRC cannot do it, then we need to have another body that can do it for ICRC. And then the other question is concerning the impact of the judgment rendered by the court. Firstly, when we talk about the advisory opinion, it is not legally binding. Even though it is not legally binding, as I mentioned before this, we cannot totally disregard it, because firstly, it is an important source of international law. Advisory opinion, it helps to develop customary international law, and secondly, it is used as it has, once the advisory opinion rendered by the court, it becomes the internal law of the body of the UN that requests for the advisory opinion. So therefore, if the court rendered the advisory opinion later on, it becomes the law of the UN, in the sense that the General Assembly use it in order to deal with the conflict involving Israel and Palestine. And then in this, and then the other case, Africa and Israel, that in that case, that is legally, the decision rendered by the court will be binding on the part of states. And then it can be enforced because the UN Charter provides that the Security Council has the power to enforce the judgment. But as Madam Nurida mentioned just now, there is a problem because it can be vetoed by the permanent members of the Security Council. So this is where I echo scholars such as Kristen Tam. We need to think that compliance is not the paramount it's something which is considered as too important at the ICJ proceeding, because whatever thing being decided by the court, it cannot be ignored. It can lead to, it can escalate, or it can trigger settlement mechanism at the diplomatic level. Thank you.
Thank you very much. I think I would like to invite all the participants to give applause to all the panelists for all the. We are now reached the end of our sessions. I would like to thank once again the panelists and all participants for very productive. And I can see that you have a high enthusiasm to engage in the discussions. I believe this is because a very important issue. I don't want to. I rather have. I would like to just to sum up some of the issues that we have discussed very briefly. The first one is that the issue of Palestine and Israel is a complex one. I think if we would like to understand the issue, it requires us to look at the historical context and its root cause. In particular, the violation of the right to self-determination of the Palestinian people. And secondly, the enforcement of international law against Israel is important to seek Israel accountability for its violation of international law. And the third one is the efforts currently instituted at the ICJ, namely the advisory opinion and the application of the Genocide Convention, are two very important measures to fight Israel impunity. And I think I fully share with your views, Professor Asari, that we should fully support the ongoing process. There's at the ICJ, we have high hopes of the ongoing process that's been taken, namely the advisory opinion, as well as the case brought by South Africa. So I think I would like to invite all of us to not only follow closely, but also to support these two ongoing process. Again, I would like to thank all of you for the opportunity and for the productive discussion. I would like to now to give the floor back to the Master of Ceremony. Once again, thank you very much. Good afternoon.
Thank you very much, Mr. Indra, for your skillful moderation. And our heartfelt thanks to the esteemed speakers for their valuable insights. And now, we're moving on to the next agenda, which is giving souvenirs to Mr. Indra and Madam Nurhalda by the Dean of Faculty of Law, Universitas Pancasila, Professor Dr. Edi Pratomo, SHMA, and also the Vice Dean of Faculty of Law, Universitas Pancasila, Dr. Zaitun Abdullah, SHMH. Could you please come forward, please? Mr. Indra and Madam Nurhalda, could you please come forward as well? Thank you. And also to all the officials of Faculty of Law, Universitas Pancasila, could you please come forward to have a photo session? Thank you. To all the officials of Faculty of Law, Pancasila University, could you please come forward to have a photo session? Thank you. Thank you very much to all the speakers, and all the certificates will be given shortly. Thank you. Sadly, we have come to an end of our seminar. Hopefully today's event brings us many benefits. On behalf of the organizing committee, we extend our heartfelt gratitude. In closing, I bid you a happy and healthy farewell in the spirit of Pancasila. Thank you, and see you everyone.
Thank you very much.
Indonesia, negara dengan jumlah penduduk keempat terbanyak di dunia, menghadapi begitu banyak permasalahan hukum setiap harinya. Sehingga dibutuhkan tenaga yang handal di bidang hukum untuk menjawab dan menyelesaikan berbagai tantangan yang semakin rumit di bidang hukum. Fakultas Hukum Universitas Pancasila berdiri sejak tahun 1969, berlokasi strategis bagian selatan, daerah khusus Ibu Kota Jakarta. Dengan predikat program studi terakreditasi A oleh Badan Akreditasi Nasional Perguruan Tinggi Republik Indonesia, Fakultas Hukum Universitas Pancasila memiliki visi untuk menghasilkan lulusan berkualitas dan profesional berdasarkan pada nilai-nilai Pancasila. Menjadi program studi ilmu hukum perguruan tinggi swasta favorit ke-6 se-Indonesia, kegiatan akademis Fakultas Hukum Universitas Pancasila memiliki kurikulum yang adaptif, produktif, inovatif, dan kontributif. Didukung tenaga pengajar yang profesional yang tidak hanya akademisi, tetapi merupakan advokat, saksi ahli di berbagai persidangan dalam dan luar negeri, tenaga ahli di lembaga-lembaga negara, dan narasumber di berbagai forum baik tingkat nasional maupun internasional. Demikian juga tenaga pendidikan yang handal, serta dilengkapi dengan sarana prasarana yang sangat memadai. Ruang kelas dan berbagai ruang pertemuan dengan fungsi yang berbeda. Seperti Aula Nusantara yang sering digunakan untuk kegiatan seminar dengan daya tampung 500 orang. Ruang Plato untuk kegiatan diskusi dan debat hukum. Ruang Sokrates untuk peradilan semu, di mana mahasiswa berlatih tentang proses beracara pada peradilan Indonesia. Ruang laboratorium hukum untuk legal drafting. Ruang laboratorium konsultasi dan bantuan hukum untuk memberikan konsultasi dan bantuan hukum kepada masyarakat yang membutuhkan. Perpustakaan dengan fasilitas yang lengkap. Taman baca yang asri. Musola. Dan berbagai ruang lainnya yang dilengkapi dengan teknologi terkemuka. Untuk bidang non-akademis, Fakultas Hukum Universitas Pancasila menyediakan berbagai unit kegiatan mahasiswa atau UKM yang memberikan kesempatan bagi mahasiswa untuk mengembangkan soft skill mereka, seperti UKM Debat Hukum, UKM Peradilan Semu, UKM Sendal Jawa, UKM Neraca, UKM Marching Band, yang telah menjuarai berbagai kompetisi di tingkat regional dan nasional. Sebagai satu-satunya program studi di Universitas Pancasila yang memperoleh hibah dari Kementerian Pendidikan dan Kebudayaan Republik Indonesia,